So question number 24. Non-registration of a firm will not affect. So if any firm is not getting registered, then what it will not affect? Option A says the right of the partner to sue for the dissolution of the firm or for the accounts of the dissolved firm or for share of the property of the dissolved firm. Option B, the right to any suit or claim of set-off not exceeding rupees 100 in value. Option C, the right of a firm or partners of a firm having no place of business in India. And option D, all of the following. So out of this, the correct option is option number D, all of the following. Any firm which is not registered, then these things will not be affected. Like the right of the partners to sue for the dissolution, it cannot get affected. And also the right to sue, it cannot get affected. The right of other firms or having no place in business or place of business in India, it also doesn't get affected. So the all of the following. So the correct option is option number D. Now come to question number 25. How a firm may be dissolved? So a firm, that means the end of the partnership and also end of the firm. So a firm may be dissolved by, option says like this. A firm may be dissolved by the court order. Option B says a firm may be dissolved by the order of tribunal. Option C, a firm may be dissolved in accordance with a contract between the partners. And option D says all of the above. So the correct answer for this question is option number D. A firm may get dissolved by the court order, by the order of tribunal, by the contract between the parties. Now come to question number 26. Question number 26 says, on attaining the majority, the minor partner has to decide and give a public notice within the prescribed period whether he will continue as partner in the firm or will quit. So what is that prescribed period? So this is the case whenever a minor has attained the majority, he has to decide by giving a public notice whether he will continue as a partner in that firm or he will quit. So what is the prescribed period for this? So there are 4 options. Option A says within 12 months of his attaining majority or of his obtaining knowledge that he had been admitted to the benefit of partnership, whichever date is later. Option B says within 3 months of his attaining majority or of his obtaining knowledge that he has been admitted to the benefit of partnership, whichever date is later. Option C says within 6 months of his attaining majority or of his obtaining knowledge that he has been admitted to the benefit of partnership, whichever date is later. And option D says within 9 months of his attaining majority or of his obtaining knowledge that he had been admitted to the benefit of partnership, whichever date is later. So the correct option, the correct answer for this question is option number C. Within 6 months of his attaining majority or of his obtaining knowledge that he had been admitted to the benefits of partner, whichever date is later, he has to inform. Okay. Now come to question number 27. What are the general duties of a partner? So what are the general duties of a partner in a partnership firm? So the option says like this. Option number A, to render true accounts and full information of all things affecting the firm to any partner or his legal representative. Option B, to carry on the business of the firm to the greatest common advantage. Option C, to be just and faithful to each other. Option D, all of the above. So the correct answer for this question is option number D, all of the above. These are the general duties of a partner. Now come to question number 28. In which conditions a person may be deemed as partner by estoppel or holding out? So what is that condition? So option A says when he by his conduct represent himself to be a partner in a firm. Option B, when knowingly permit himself to be represented to be a partner in a firm? Option C, when he expressly by words spoken or written let the other that he is a partner in a firm. So in this case, option D says all of the above. So the correct answer for this question is option number D, all of the above. Whenever a person by his conduct, by his conduct represent himself as a partner, whether he is actually not a partner, or knowingly permit himself to be represented as a partner, or by his words spoken or by written, he let others that yes, he is a partner in a firm. So in that case, all the above conditions if satisfied, then so the correct answer is D. These are the conditions under which a person may be deemed to as a partner by estoppel or holding out. Now come to question number 29. Question number 29 says, Messrs. XYG is partnership firm and XYZ are the partners. During the course of business travel, partner X recovered a sum of rupees 15,000 in cash form from the debtor of the firm and credit in its personal account. So the act of X will amount to what? So definitely, as we know, the general duty of a partner in a partnership firm is to act just and equitable. So in this case, in the partnership firm of Messrs. XYZ, X has recovered a sum from debtor of rupees 15,000. But what he has done? He has credited this sum to his own personal bank account. This act is definitely not a just and equitable act. So what will be the options and what will be the correct answer for this? So the option A says, after utilizing the amount for a few days, he returned back the money to the firm. So it will not come under the misappropriation of the funds. Option B says, nothing wrong in it since he has been personally made effort in realizing the dues from the debtor. Option C, misappropriating the funds of the firm and utilizing of the same for the personal gain. And option D says none of the above. So the correct answer for this question is option number C. Yes, this is called as misappropriating the funds of the firm. So the correct answer is misappropriating. Here X is misappropriating the fund of the firm and utilizing of the same for his personal gain. Okay. Now come to question number 30. After the dissolution of a firm, the authority of each partner to bind the firm and the other mutual rights and obligations of the firm shall continue. Okay. So let me tell you, it says, this question says that after the dissolution of a firm, the authority of each partner still bind to the firm and other mutual rights and obligations of the partner shall what it will be the condition. So the option A says to complete transactions begun but unfinished at the time of the dissolution. B says to wind up the affair of the firm. Option C says both A and B are correct, and option D none of the above. So the correct answer for this question is option number C. Both A and B are correct. That means if a firm is getting dissoluted, in that case, in that situation, they have to first complete the transaction which they have begun. But if unfinished at the time of the dissolution, then shortly they have to complete the transactions. Then number B says to wind up the affair of the firm. So both A and B are correct. Now come to question number 31. How the settlements of debt will be made in case there are joint debts due from the firm and also separate debt due from any partner. So how the settlement will be made? Option A says debt of the firm shall be paid first out of the property of the firm, but in case of private debt of the partner, it shall be paid in last if there is residue after paying of all the dues of the firm. Option B says, debt of the firm shall be paid first out of the property of the firm, but in case of private debt of the partners, it shall be paid in last if there is residue after paying all the dues of the firm. Option C says, debt of the firm shall be paid first out of property of firm, and if there is any surplus, it shall be distributed among the partners. And option D says both A and C are correct. So the correct answer for this question is option number D. In case there has to be made a settlement of debt, in that case, first of all, debt of the firm shall be paid out of the property of firm, and in case of private debt of the partners, then it shall be paid in last if residue is left after paying all dues of the firm. And option C, like it says, debt of firm shall be paid first out of property of firm, and if there is any surplus left, then it shall be distributed among the partners. So the correct answer is option number D. Both A and C are correct. Now come to question number 32. A transfer by a partner of his interest in the firm, either absolute or by mortgage or by creation by him or a change on such interest, does entitle the transferee during the continuance of the firm. So the options are like this. Option A says to require accounts of the firm. Option B, to inspect the book of the firm. Option C, only to receive the share of profit of transferring partner, and the transferee shall accept the account of profit agreed to by the partners. Option D, to interfere in the conduct of the business of the firm. So the correct option is option number C. Whenever there is a transfer by a partner of his interest in the firm, whether it is be absolute or by mortgage or by creation by him of any charge on such interest, in that case it can be only made to receive the share of profit. So the transferee can only have the right to receive the share of profit of transferring partner, and the transferee shall accept the account of profit agreed to by the partners. Now come to question number 33. Subject to contract between the partners, the property of the firm includes. That means there is full liberty to the partners. They can make the contract according to their wish. Okay, but the general view is that the property of the firm includes option A, acquired by purchase or otherwise by or for the firm or for the purposes and in the course of business of the firm. Option B, the goodwill of the business. Option C, all property and rights and interest in property originally brought into the stock of the firm. And option D, all of the above. So the correct option, the correct answer is option number D, all of the above. That means the property of the firm include all the acquired, all the purchase. Okay, all the acquired, all the purchases which are brought by the firm in the course of business, all the goodwill, all the property and rights and interest in property which are brought into stock of the firm, they all are the property of the firms. Now come to question number 34. What are certain contingencies when the firm has to be dissolved subject to contract? Like I said, there is full liberty how a contract should be made by the partners, but there are certain contingencies also when the firm has to be dissolved. Like the option A says by the death of the partner and by the adjudication of a partner as insolvent. Option B, if constituted for a fixed term by the expiry of that term. Option C says if constituted to carry out one or more adventures or undertaking by the completion thereof. And option D says all of the above. So the correct answer for this question again is option D, all of the above. That means a firm can be dissolved by the death of a partner or by the adjudication of a partner as an insolvent, or if that firm is made for a fixed term, or which we called as the particular partnership. So whenever that date or that duration is expired, then automatically the partnership has to come to an end, And option C says, if it constituted to carry out one or more adventures or undertaking, and if that is completed, then the partnership has to be dissolved. So all of the above options are correct. So the correct answer is all of the above. Now come to question number 35. To start a partnership business, what should be the minimum and maximum number of partners? It's a very easy question. So let me tell you, to start any partnership business, we have to need at least 2 persons who are going to be the partner of that partnership firm. And the maximum number of partners in any partnership firm, it is actually not written in the Partnership Act, but it is written in the Companies Act. In section 464, it says that in any unorganized or unregistered sector, the maximum number of partners or maximum number of members should not exceed 100. And again there is rule number 10, which says no, in that case it only need to be 50. But to be in a whole, keeping in view section 464, it is the maximum number of partners is 100 partners. So the minimum number of partners to be in a partnership business is 2 and maximum number of partner is 100. The correct option is option number A. Now come to question number 36. What is the liability of a retiring partner after the death of his retirement? So options are like this. Option A says, he shall not be liable for the act done by other partners during his tenure in the partnership firm. Option B, he and the partners continue to be liable as partners to third party for any act done by any of them which would have been an act of the firm if done before the retirement until public notice is given of the retirement. Option C, he shall be liable for the act done by him only on behalf of the firm during his tenure towards the third party. And option number D, only A and B are correct. So the correct answer is option number B. He and the partners continue to be liable as partners to third party for any act done by any of them which would have been an act of the firm if done before the retirement until public notice is given of the retirement. So this is the correct answer. Now come to question number 37. What shall be the treatment of goodwill in settling the accounts of a firm after dissolution? Option A says, the assessment of the amount of goodwill is a difficult task and cannot be precisely calculated. Hence, it should not be considered. Meaningless. Okay. Option number B. The goodwill shall, subject to contract between the partner, be included in the asset, and it may be sold either separately or along with other property of the firm. Option C says the goodwill is an intangible asset and should not be accounted for. And option D says none of the above. So the correct answer, that means what should be the treatment of goodwill in settling the account of firm after dissolution, is option number B. The goodwill shall, subject to contract between the partners, be included in the asset. So as an asset, the goodwill may be sold either separately or along with the other property of the firm. Now come to question number 38. The partners in a firm may, by contract between the partners, what they can do? Option A says restrict the implied authority of any partner or extend the implied authority of any partner. Option C says none of the above. And option D says both A and B are correct. So the correct answer is option number D. Both A and B are correct. That means the partners in any firm, by contract between them, can restrict the implied authority of any partner, and also they can extend the implied authority of any partner. That is the correct answer. Now come to question number 39. It says like this. In the absence of an agreement, interest on partner loan shall be paid at what rate? So, as per the law, the interest rate is, among these options, the correct option is option number B, that is 6%. So, the interest on partner loan shall be 6% per annum. Now come to question number 40. Goodwill brought in by an incoming partner in cash to join a partnership firm is shared by the old partners in their what ratio? So the options are like this. Option A says new profit sharing ratio. Option B, old profit sharing ratio. Option C, capital ratio. And option D, sacrificing ratio. So whenever an incoming partner comes and he brought goodwill in cash to join the partnership firm, then it shall be done by the old partners in their sacrificing ratio. So the correct answer is option number D, sacrificing ratio. And with this video has come to an end. I hope it will be beneficial for you. Thank you for watching, and please do like, share and subscribe to my channel.